Your Honor, I don't believe that there is a question of whether it's an order of the circuit court of Racine County. And I think that all of the arguments that opposing counsel made are appropriately made to the Racine County Court, and his elaboration of a decision needs to be made, whether these were, that what DHS did, the plan that DHS put together, whether that comports with Chapter 980, that decision was made by a Racine County court. And if I may, Exhibit 1 of our filing, and I don't know, a courtesy copy if you would like it.
Yeah, I'm not sure what, I've seen that. Because I know I've got, yes, this is what I saw, and I did review this.
And as I read it, it both is captioned in order for supervised relief, and before the judge's signature is stated, this is a final order for purposes of appeal. I think on the face of this, and as you read it, it is an order. It orders placement of supervised release and placement of this individual, Michael McGee, in the secured facility designated in the plan. And to the extent that Thursday comes, the sheriff has been ordered to transport this individual to that residence.
Not to get ahead of the game, so to speak. I did review that order, and I went through the statutes, both the current and the old one. Those are some of my modifications. And you can't tell there it says the supervised release plan is approved. Obviously, it's not attached. So I don't know if that's at Kenosha County, except one of the questions I had when I was doing this, was the county selecting the Racine case on May 4th when the order was signed? I can't tell. And I don't even know in the Milwaukee case, although it's going back now, that go back to judges currently signed. I'm using Judge Brash because he signed the initial order in Milwaukee after October 13, 2015, because the statutes require within 60 days or before you change, because it had to be determined, so the court had to have it back at some time to make that determination of where it was going, even under the old statute, because that language had to change. But that aside, I didn't want to interrupt you. I'm just showing I don't know. But go ahead.
Yeah, and to the extent, obviously, we have not filed I think the supervised release plan in the Racine County case with the court. I do have a copy that was attached to, I believe, one of Mr. Terry's filings in the Racine County matter in his motion to intervene. So to the extent that we need a copy of that, I believe I have that, and we can move forward. But largely what's being asked here today of you is to review the Racine County Court's judgment. And that is not what circuit courts do. That's what appellate courts do. As stated in our very short brief, I think that's black letter law. And to the extent that the town is asking to restrain DHS from following another court's order, I think that the reason why that black letter law exists is because it would put DHS in a position where it would be in contempt of one court. We would have two competing orders ordering us to do opposite things, because a Racine County court has made a determination that this was a valid placement under 980. Whether or not he changes his mind tomorrow is to be seen, and whether or not DHS even would agree with any determination of the court. It's a court order that we are obligated to follow.
Yeah, I understand what you're saying.
I guess that's the position where we're in. If you want us to get to some of the factual issues in this case, I think we can talk about them in general terms. Obviously, because this was a TRO, we did not bring witnesses
Sure.
to present any testimony.